but we have to consider the actions of the defendant. And I think to a probable cause standard, there is certainly a question of fact as to the defendant's intent. But unequivocally, if you take a Ford Explorer and you floor it and you aim it at someone, you can kill them. That is just common sense.
Yo, your boy Oouchie back in the building. And today we in Judge Cedric Simpson's court for a preliminary exam. That means nothing's proven yet. Everything's alleged. But the state says a man tore through a neighborhood in a stolen SUV at 130 in a 25, then drove it straight at a deputy. 5 counts, 1 prelim. Let's ride.
Hannah Mackey, hearing within on behalf of Chalice McLaughlin.
All right, very good.
Andrew Childers appearing on behalf of the people, Your Honor.
All right. And this is a continuation of a preliminary examination, which I believe, I think it was Detective Rob was on a call that day.
That's correct.
Now he's here. And so you may call your next one.
I think our people would call Thomas Robb to the stand.
All right. Sir, please come forward to be sworn.
JC, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth?
I am.
State, spell your first and last name correct.
Thomas Robb, TH, R-A-G.
Sir, thank you, Your Honor. Sir, how are you currently employed?
I've been with Washtenaw County Sheriff's Office.
And how long have you worked with the Sheriff's Office?
4 years.
Were you working in that capacity back?
Real quick, lock this in. This ain't a trial and it ain't a verdict. Simpson's only job today is deciding if there's enough smoke to send this to a real jury. 5 counts on the table, including an alleged attempted murder. So keep alleged glued to every word.
Back on April the 5th this year, 2025?
I'm licensed as a road patrol deputy.
Road patrol deputy? Thank you. Directing your attention to around 7:30, 7:45 in the morning, were you in the vicinity of the West Willow neighborhood?
I was.
Okay. And on that date and time, what was your shift?
Sorry.
What was your shift that day?
I was working day shift.
Okay. What time did you start?
8 a.m.
8 a.m. Okay.
I believe the 7:30 time was when the call initially came in.
Okay. At some point, as your shift started, were you made aware of an investigation regarding a possible stolen Ford Explorer?
I was.
Okay. And who made you aware of that?
Deputy Phillips.
Okay. And what, if anything, happened in that morning on April the 15th that led to you being involved with that Ford Explorer in any way?
Deputy Phillips told me that he'd taken a stolen vehicle report for that vehicle. He advised that he had gained GPS location for the vehicle from the victim. That was pinging, I believe, on Brookside, which was in the West Lowell neighborhood. He advised that he was going to go check the area for the vehicle and asked me to assist.
Okay. Were you and Deputy Phillips in the same patrol vehicle or separate patrol vehicles?
Separate.
Okay. To your knowledge, did Deputy Phillips arrive in the area of that suspected stolen vehicle before or after you?
Before.
Okay. How did you know that?
I heard a call.
So here's the setup the deputy lays out. A gray Ford Explorer gets reported stolen, and the owner's own GPS is snitching on it in real time. 2 deputies start closing in on a routine morning stolen car call. Nothing wild yet, but a boring stolen car call is about to grow legs.
Okay. When you heard him call that out, where were you?
A few blocks away.
Okay. And what happened next?
After he called out that he was out with the vehicle, again, I believe it was on Brookside. I was a few blocks away. I heard mic clicks on the radio. That's pretty much when somebody depresses the talk button on the radio, but doesn't have a chance to get transmission out. In my 7 years of doing this job, normally when I hear that, that tells me that the deputy's in trouble. There's some kind of accident that caused them to interrupt their transmission, whether they're chasing someone or fighting or something of that nature. So that gave me cause for concern. I continued towards that location where Deputy Phillips was at, and then I saw the, I believe it was 2024 gray Ford Explorer. That was the vehicle in question, speaking out of the neighborhood.
So as you're entering the neighborhood,
Then it gets heavy. The deputy says he hears mic clicks on the radio. That talk button hit with no words, which to a cop means somebody's in a fight for their life. He rolls into the neighborhood and the Explorer ain't hiding. It's coming right at the mouth of the street. Silence on a police radio is louder than any silence.
Exiting the neighborhood?
Correct.
Okay, what did you do next?
I recognized that it was the vehicle we were looking for. I believe Deputy Phillips was in danger or something had happened, so I activated my emergency lights and siren to try to stop the vehicle.
Okay, and did you have to turn your vehicle around?
No, I was coming right at the entrance to the side street where the vehicle, the Ford Explorer, was coming out from. So
Okay.
I was driving directly at it.
Got it. And did you in fact then begin a pursuit of that vehicle? Okay, and that started in this West Willow neighborhood?
Yes.
Okay. What is the speed limit on the road there where you initiated this chase?
It's a residential neighborhood, so 25 miles an hour.
Okay. Did the vehicle pull over after you activated your overhead equipment?
No.
Okay. What happened next?
The vehicle accelerated and tried to evade me.
And did you continue to pursue the vehicle?
I did.
And for how long did you continue to pursue this vehicle before it was eventually stopped?
I believe about 10 minutes or so. I don't recall exactly the time.
Okay. Where during that time, do you know, Detective Rob, what speeds did you get to?
I believe maximum speed was about 130 miles an hour.
130?
Yes.
Okay. What sort of vehicle were you in?
A Ford Explorer.
Okay.
It was a fully marked patrol car.
Thank you. At what?
Now, the number that made me sit up, the deputy says this chase hit about 130 miles an hour in a neighborhood posted at 25. That's the state's whole "you endangered everybody" angle right there. Allegedly turning somebody's front yard into a runway is how one bad morning becomes 5 felonies.
Point did this chase terminate in any way?
Van Buren police assisted us with the pursuit. It was a Van Buren officer deployed stop sticks, which the stolen vehicle ran over, which caused, I don't know if it was one or multiple tires to deflate, and then the vehicle crashed into a berm at the entrance to a neighborhood. I believe it was on the end of any course roads.
And that's in Van Buren Township?
I believe so.
Okay. From the time period that you started this pursuit in the West Willow neighborhood to the time that it ended in Van Buren Township, did you ever lose sight of this Ford Explorer?
No.
Okay. After the vehicle was hit the stop sticks and crashed into the ditch, were you able to determine if the vehicle was occupied?
Yes, I was.
And were you able to see anyone in that vehicle?
Yes.
Okay. Are any of the individuals that you saw in that vehicle on April the 15th in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
Yes, it was Giles McLaughlin. He's sitting to my left wearing a green jumpsuit.
And where, Your Honor, may the record reflect in court identification of the defendant?
Without objection, record shows so reflect.
And where in the vehicle?
Van Buren cops toss the stop sticks, the tires give out, and the Explorer eats a berm at the neighborhood entrance. And here's the fact that carries legal weight. The deputy says he never lost eyes on that truck the whole time. And when he got there, the state says the defendant was alone in the driver's seat. In court, "I never looked away" is worth more than any confession.
Driver's seat of this vehicle.
He was exiting the driver's seat. I told him to show me his hands and get on the ground. He did. I placed him in handcuffs.
Okay. Did he appear to be injured in any way?
I believe he had some scrapes or bruising on his arms. Maybe, I think he might have had a small amount of blood on his lower lip, if I recall correctly.
Okay. Is it, do you recall, did like the airbags deploy in this crash?
I don't recall.
Okay. I have no further questions, sir. Thank you.
All right. Thank you. Cross-examination.
Good afternoon, Deputy Rob. You were in pursuit of the vehicle in question,
Yes.
and you followed that vehicle for around 10 to 15 minutes.
Around there.
And during that time prior to the accident, you got no closer than 50 feet, did you?
I got no closer
To
than,
the vehicle than 50 feet, would you say?
I don't know how close I got during the pursuit. I guess 50 feet might be accurate about closest I was, but I don't recall without reviewing the camera footage.
And you testified on direct that during the course of the pursuit, you activated your sirens. Is that correct?
Yes.
And at some point you were driving on the highway?
Yes.
Was it a busy highway?
I would say there was a medium amount of traffic.
So that means that there were other cars on the highway during the pursuit.
Yes.
And you had to make several lane changes to navigate through that traffic, didn't you?
Yes.
And some of those cars.
Watch what the defense does on cross, because this is chess. They get the deputy to admit he never got closer than 50 feet and can't be sure without the footage. Then they plant a seed. Could the driver even hear the sirens? That ain't drama for nothing. Cross-examination is where lawyers dig the trap the whole case is going to fall into.
The shoulder of the freeway, is that correct? You don't know why some of the people did not pull over to the side, do you?
Well, without talking to them personally, no, I wouldn't know why.
So you don't have any personal knowledge then as to whether or not the drivers of the vehicles could hear the sirens?
I suppose so, yeah, without talking to them.
So then it would be fair to say that you didn't know why those vehicles did not pull over?
I guess so.
And you don't have any personal knowledge that Mr. McLaughlin could or could not hear the sirens, did you?
I suppose not.
Thank you, Your Honor. No further questions.
Right. Can you redirect?
No, Your Honor. Thank you so much.
Sir, thank you.
Thank you.
Your Honor, with Detective Rob's testimony, the people have no further witnesses, the people press.
Any witnesses for the defense?
None for the defense, Your Honor. Thank you.
All right.
Now, people would move to bind the defendant over as charged on the information before the court. I believe it is 5 counts. Yeah.
Yes.
5 counts.
Deputies excuse, the state rests, defense calls nobody. So now it's pure lawyer ball. The prosecutor asked Simpson to bind over all 5 counts, and bind over don't mean guilty. It just means the state showed enough to earn a seat at the big boy courtroom.
Mr. Brown responds.
Thank you, Your Honor. Your Honor, the court listened to the testimony previously from Deputy Phillips. It also heard the testimony from Deputy Robb. So the counts that we have that the prosecution is requesting for bind over are assault with intent to murder. That would be on Deputy Phillips. There's fleeing and eluding. That would be on Deputy Robb. There's receiving and concealing a motor vehicle, an unlawful driving away, and a resisting and obstructing causing injury. And I think that last one goes to Deputy Phillips. So I know it's been a bit, so we probably should go over what the prior testimony was. The testimony from the Deputy Phillips was that on April 15th, he was on road patrol. He'd gotten a call that referenced a stolen vehicle at the Marriott. He responded, had contact with the owner. The vehicle described as stolen was a gray Ford that was stolen sometime during the night. I don't know if we ever really narrowed that down to exactly what time that vehicle would have been stolen. That was entered into lien.
Defense walks the whole charge stack, the alleged assault with intent to murder on one deputy, fleeing and eluding on the other, plus the stolen car counts. This is the map, so keep 2 fights in your pocket. Did he really mean to kill on count 1? And who actually drove this thing away on the stolen car counts? Everything from here swings on those 2 doors.
At some point, they got to the cul-de-sac in West Willow, where the GPS told them that the vehicle would be found. They first got there, they couldn't see the plate because the vehicle was facing them. I believe that when they pulled up, they were facing the vehicle. They were probably, 20 to 30 feet away from the vehicle. Again, it was facing them. And while they may not have been directly hit on, they were in front of them with their headlights facing each other. The officer testified, Deputy Phillips, that he could see that there were at least 2 people in the vehicle at the time, that they pulled up. But then once they came to a stop, they said they were going to conduct a modified felony stop. Deputy Phillips said to unholster his pistol. 2 passengers then got out. And so 2 people got out of the vehicle, and they started walking away from patrol car as well as the vehicle that they were in. Said he couldn't see the driver at first.
Now rewind to the cul-de-sac and slow down with me. Deputies 20, 30 feet off, headlights nose to nose, and per the testimony, there's at least 2 people in that truck. Gun comes out, a modified felony stop, and 2 passengers just climb out and walk off. This is the exact kind of morning that could have ended with a whole lot more than a court hearing.
Later could see who the driver was at about 15 feet. Said he yelled to the driver to turn the car off, so I believe the car was still running at this time. This point, his weapon is drawn. He says that he stepped out away from his vehicle into a space. This is a cul-de-sac, and as the testimony was developed, there was a space between the front of his vehicle, where he was the passenger, got out, and a space in the street from where a vehicle could pass through. He said he got out, couldn't recall whether or not he'd raised his hand, but he did get out and he got into that space. He said he could see the vehicle, the wheels turning, and that the car then drove at him without veering. He had his weapon drawn, and the vehicle, once it got started.
This right here is the ball game. So no jokes. The deputy testifies he stepped into the one and only gap a car could squeeze through, weapon drawn, and watched the wheels turn toward him. And according to him, that Explorer came straight on. No swerve, no veer. Whether count 1 lives or dies is sitting on that single eddy, it didn't turn.
But it did not stop. Drove at him, clipped him on the knee as he had to jump to get out of the way of the vehicle. He did say that the vehicle does not stop after that. I asked him if the driver said anything to him. He said that there was nothing said, no threats made or anything like that. He did say he had recognized the driver as Mr. McLaughlin. He then testified that he and his partner then got into the vehicle and left in pursuit. So what we have then is the vehicle stolen sometime in the night. We do not know, or there was no testimony given as to who drove that vehicle away. We do know when the vehicle is seen again, there are 3 people in the vehicle. And I'm not clear as to how much.
The deputy says the truck clipped his knee as he had to jump clear, and it never stopped. But here's the honest part. The driver said nothing, made no threats. And that's the crack the defense prees open. 3 different people were around this car. No words spoken, and 3 suspects is a lot of reasonable doubt to hand a jury.
Time has passed. It's been a few hours. So we don't know if the person who took the vehicle, drove the vehicle away from the scene, is even in the vehicle when it's reached at West Willow, because there's been no testimony given for that. If the court remembers differently, certainly they could say, but as I recall the testimony, they spoke with the person who owned the vehicle, and they simply said that the vehicle was taken in the night and they had a GPS and they're able to track them. So at the time that the officers or deputies are looking for the vehicle, tracking the vehicle, they have no idea who has taken the vehicle, male or female, white or black, fat or skinny, tall or short. There is no description of the driver or the person who actually drove away with the vehicle. We just don't have that. But what we do have is 3 people who are associated with the vehicle. 1 person is in the driver's seat, and several hours that have passed since the vehicle was driven away from the spot. So let's go back to the first charge, which is assault with intent to murder. So based on Mr. Chalice McLaughlin driving at the officer who was in his face, through which the vehicle must pass in order to.
The defense comes with a clean 1-2. 1, y'all never proved who stole or drove this thing hours later. And 2, aiming and reckless ain't the same as intending to kill. And on paper, that's real lawyering. Intent to murder is a mountain, not a speed bump. Reckless will get you charged. Planning to kill is a whole different animal.
8-1 Mishap 515, 1978. there must be some time for premeditation and deliberation. So remember, the court may recall that it was 6 seconds from the time the officer got out of his vehicle and stood in that area in order to stop this vehicle from leaving. 6 seconds. Now, the law does not define how much time you need for planning and premeditation. It doesn't do that. But it is clear where there is no evidence of planning and motivation. And they have to show that. They have to show some planning, some motivation to kill this person. What you've seen is a motivation to leave, to flee the area, perhaps. But there is no evidence put before this court that when this vehicle was driven at that officer, that the plan or the motivation, the intention or the premeditation was to kill anyone. And they have to show that. It's not enough that they show, well, it's likely.
But isn't that really a question of fact?
No.
As to whether or not
Good question.
the evidence is sufficient?
Good question. Because People versus Oster, 67 Mich. App says, where there is no evidence of planning or motivation, bindover is erroneous. So
Here's the brain of the whole case. 6 seconds from when the deputy stepped out to the alleged hit, and defense says that shows a man trying to flee, not plan a killing. But watch Simpson flip into professor mode. Ain't that a question for a jury, though? Sometimes the shortest amount of time asks the biggest question.
Your Honor.
Well,
And I don't think that's...
it can be, it can be that. But even when you're talking about it being murder, what you're doing is you're implying the premeditation necessary.
Because it's a police officer, so forth. So what you're saying, in some clear...
I asked the question, isn't there an exception?
I do not believe there is. I do not believe that the law changes. And Your Honor, that's equal protection. My client is entitled to equal protection under...
I don't think it has any equal protection implication. It's just a question of whether or not under the statute that gives that there is an exception.
Well, it is
equal protection. An exception.
It is equal protection in that my client is entitled to, and again, I don't believe that this exists. Certainly, we can research it if the court believes that actions.
I just asked the question.
Well, okay. So my response is, I do not believe that that is a thing. I do believe that that's a thinking and charging what in every other case is always charged as a felonious assault. I do believe that there's a thinking, and that's where the equal protection comes in. That's exactly where the equal protection comes in.
I don't know.
Because my client
I don't know if that's equal protection.
Well, I'll explain to you why I think so.
Well, I don't need it.
Okay.
Because I don't think
you've rejected it up front. Okay, fine.
I rejected it outright.
Okay. All right.
And the temperature jumps. Simpson floats that going at a cop might carry premeditation built in. Defense fires back. There's no special officer exception, and it gets short real quick. The real question under all that heat, does the law treat an alleged attack on a badge different? Is a fair one, even when the room ain't.
You don't know that he was at the hotel. You can't, and that's...
I'm just saying it won't matter where you start, though. I'm not saying that there's an indication that he necessarily took from the hotel. If you concede that point, I'm saying the unlawful driving away can happen at the point of the cul-de-sac.
Then how do you get receiving and concealing stolen property? How do you distinguish the two if you're going to say it's always a...
I'm not here for reasonable doubt. I'm not here to answer your questions. So you can go ahead with your argument.
All right. So let's make sure that we're clear on that. Unlawful driving away demands that the person take the vehicle, take possession of the vehicle, in contradiction or in contrast to the owner. If he takes possession of the property from someone else who stole it, he's not an unlawful driver away of the vehicle. He may be someone who receives and conceals. The problem for the prosecution's case, Your Honor, is they have not established who took the property from the owner, or at least where the owner had the property last. And they have to do that. Just because you can say that he was in the vehicle later does not and cannot support a UDAA. At best, it can support a receiving and concealing of stolen property if you go with the thought that recent possession of stolen property, knowledge that the property itself is stolen. But it does not.
Now the stolen car nerd fight, unlawful driving away means you took it from the owner. Receiving and concealing just means you got caught holding it later. So did he steal it or inherit somebody else's mess? Then Simpson shuts the crosstalk down cold. I'm not here for reasonable doubt. Go on with your argument. Reasonable doubt is the trial's job. A prelim just asks, can it stand up?
Assault with intent to commit murder.
So I don't even need to address that issue, whether there's an exception premeditation.
There's nothing in the jury instruction
that requires. Okay.
And so then we're left with the question of is the defendant in driving a Ford Explorer at Deputy Phillips intending, can you infer from that behavior an intent to kill? And the argument before the court that the people would put forth is when you're piloting what is probably a 4,500 or 5,000 pound object, accelerating and pointing that vehicle at an individual, you absolutely, that those actions, there's a logical inference that can be argued that would create a question of fact that you're intending to kill that person. That's a mass, we're not talking about a motorcycle or a scooter or a golf cart or anything else. We're talking about a Ford Explorer. This is a large vehicle. The defendant looked, based on the testimony of Deputy Phillips, he was looking right at him. Deputy Phillips is attempting to get him to stop. He steers in the direction of Deputy Phillips, hits the gas, and hits him. Now, granted, Deputy Phillips was able to get out of the way, and it only struck his knee and kind of fell to the ground. But we have to consider the actions of the defendant. And I think to a probable cause standard, there is certainly a question of fact as to the defendant's intent. But unequivocally, if you take a Ford Explorer and you floor it and you aim it at someone, you can kill them. That's.
Then the prosecutor drops the line the whole hearing was building to. You don't need a written plan because assault with intent to murder just needs intent to kill. And the state argues you read that intent right off the act. Floor a 5,000 pound truck at a human being and quote, you can kill them. That's just common sense. That's the state's argument. But man, it lands like a closing.
That counts. And I believe the defendant should be bound over on all 5 counts.
All right. Okay. With reference to, there is no dispute as to a bind over on count 2, 3, and 5. Therefore, the court also does believe that the people have sustained their burden and the defendant would be bound over on counts 2, 3, and 5 without objection as they raise issues of fact. In terms of the unlawful driving away of a motor vehicle, again, it would be this court going into the province of the jury as to when they first saw the defendant in the vehicle. Certainly a jury could reasonably infer from the hotel, the timing and everything else that it was indeed the defendant who did that. I don't think that people have to go beyond that. So certainly under that, if the theory is correct that it's got to be taken from the location from the owner, but I don't think that that's correct. But still, even then, I think a reasonable fact finder could conclude that. As it relates to the other piece of that, I think an individual can be charged with the unlawful driving away of a motor vehicle when they took possession or assisted in taking possession of that vehicle. I don't think it excludes, it doesn't get charged or can't be.
Ruling time and Simpson moves fast. Counts 2, 3, and 5, no dispute, bound over. On the stolen car count, he says a reasonable jury could infer from the hotel, the timing, the whole picture that the defendant took it or helped take it. At a prelim, the judge won't do the jury's job for him. He just cracks the door open.
Very clear in the testimony where a reasonable fact finder could conclude the intent was Deputy Phillips' testimony that as he's there, the wheels of that vehicle are pointed right at him as it's accelerating out. It's not a circumstance where they were trying to go around him, they were trying to do whatever. And certainly a reasonable fact finder could conclude that that was an attempt to strike and kill Deputy Phillips. And that, as it then relates to count 5, maybe by the grace of God, Deputy Phillips gets out of the way. His leg is hit and injured. But that would, even though he's able to do that, that doesn't necessarily negate the intent that the defendant, or what one could find as the intent to kill in this case. And the court believes that there is sufficient evidence as it regards that under either theory of the first degree murder or under the notion of kill. I think there's sufficient evidence to go forth to a jury on that charge, and therefore the court would find that the people have sustained their burden and bind the defendant over on count one. So to conclude, the defendant will...
And the big one, count one, the alleged attempted murder. Simpson points to the wheels aimed dead at the deputy as the truck sped up, says, by the grace of God, he got clear, and binds it over. All 5 counts head to trial. But hear me loud. This is not a conviction. A jury still has the last word, and the man's presumed innocent walking through that door. Bottom line, a bind over ain't a verdict. It just means 12 strangers get to hear the whole thing, and the defendant still presumed innocent till they say different. We'll be right here when this lands in front of Judge Cannon in Circuit Court. Smash that like, subscribe to Oouchie Court Reacts, and share this with that one cousin who still thinks a preliminary exam is the same as a guilty verdict. Your boy Oouchie, out.